Please be seated. Good afternoon. Welcome to the U.S. Court of Appeals for the Fifth Circuit. We have two cases on our docket this afternoon, and we'll begin with case number 2460340, Pharmaceutical Research and Manufacturers of America versus Fitch. Mr. Perry.
May it please the court, this case is about Mississippi's efforts to fundamentally change a federal program. The 340B program is a unique federal subsidy. Under that program...
Run that first line by me. I wasn't sure I fully heard you.
Sure.
About what?
The 340B program is a unique form of federal subsidy, and here's how...
What did you say? It was about the first sentence.
Oh, the very first line, Your Honor? This is a case where Mississippi is attempting to fundamentally change the federal...
that's what I thought I heard you say.
...program. And so let me, if I might, explain what I mean by that.
Yeah, I was going to say that might be a good one for...
Thank you.
Have a little ad.
So it's a unique federal subsidy in this respect. Under 340B, drug manufacturers, and pharma represents many of them, are required in order to participate in Medicaid and Part B of Medicare to give a very significant discount on drugs to certain types of healthcare providers. The D.C. Circuit has called that discount strikingly low prices or penny prices per unit. And the covered healthcare entities are able then to sell those drugs, resell them to patients at a much higher price. That's the nature of the federal subsidy. The bounds of that obligation to provide a discount are now settled. They're settled by the D.C. Circuit's case recently, Novartis, from spring of last year, along with the Third Circuit case. And here's how it works under the statute, Section A1 of the 340B statute, so it's 42 U.S.C. 256B A1. There is an obligation on drug manufacturers to offer, Congress chose the word offer, chose a contractual construction, to offer these drugs at these severely discounted prices to these particular types of healthcare entities. In the Novartis case, that's the D.C. Circuit case, in sections 3 and 4 of that case, the court explored what was actually required under federal law by that term offer. Judge Katsas wrote for the majority that the term offer, again, incorporates the notion of contractual offer and acceptance, and that there are certain conditions that drug manufacturers can impose and comply with federal law. And it went specifically to two types of conditions. One is called a one-contract pharmacy condition, and to cut to the chase there, pharma members, including those in the declarations below, will provide drugs to either the covered healthcare provider or to one contract pharmacy under that particular policy, and that policy was held to comply with federal law. It's a reasonable delivery-related restriction on the federal obligation to make an offer, a federal law requirement. The other type of policy at issue in this case, in our declarations below, is called a claims data policy, and that is where the drug manufacturer says, as a precondition to supplying a discount, to supplying this drug discount, you have to agree in advance. I'll deliver to whatever pharmacies you'd like, but you have to agree in advance that you will provide us with data about what these prescriptions are. That has multiple purposes. One purpose of that requirement is to allow the drug manufacturers to understand what type of prescriptions they're actually providing these strikingly low prices for, these penny prices. And if they don't know that, they can't actually understand precisely what it is that they're providing discounts for. That's important for multiple reasons. One is because the statute outlaws diversion in Section A5, and also duplicate discounts with the Medicaid program. So in order to understand that, before you've provided the discount, you have to understand what these prescriptions are. It's a precondition to getting the discount. There's another reason that's important here. That's because of the very complicated federal regime for enforcement and seeking administrative dispute resolution and audits. In order to audit under federal law with this claims data policy, you have to be able to understand what the claims are. You have to make a showing of reasonable cause to the federal government in order to get an audit, and then you can't use one of the principal mechanisms of the federal regime for addressing disputes without having audited. So one contract pharmacy requirements and claims data requirements, both addressed by Judge Katsas in an opinion, both fine, both consistent with federal law, both appropriate as part of a federal offer. That particular issue is what is at stake here. And what Mississippi is attempting to do is outlaw those two types of conditions. They're threatening civil penalties and criminal prosecution for companies that scrupulously apply federal law and put the conditions forward that I just described. As a backdrop to this discussion, I might refer now to the Supreme Court's opinion in the Astra case. That was in 2011. The case came about at about the same time that Congress was amending this law. So it amended the law in 2010, 2011. And what had happened at that point was that there was a dispute between the same type of covered healthcare providers and drug manufacturers about how you enforce these federal requirements to provide a discount. And so the case came to the Supreme Court, and as this was happening, Congress changed the law. And what Congress did is add Section D and made some other changes, but Section D of this statute is very important because it explains in detail how to enforce the federal requirements before a federal agency subject to review by federal courts. And what Congress did, and this is explicit, the Supreme Court described this in detail and described Congress's intent. Congress said that the proper remedy for these types of disputes about overcharges by manufacturers or any other violation of this federal obligation to offer is to go through the system that we created in 2010 that's now Part D of the federal statute. That's how you essentially solve these issues when they arise. Now, what the state is trying to do here is create a competing regime that imposes different types of remedies for these same issues. Now, if I might, Your Honor, there are a couple...
Let me ask a quick question about Astra.
Yes, sir.
If that's pronounced correctly. As I understand it, Astra is about whether there's a private right of action, even though there was none set forth by Congress.
It is, Your Honor, but here I think is why that's relevant. The county, Santa Clara County, was saying we want to find some way to enforce the 340B requirements outside the federal regulatory system. In other words, we want to go outside the federal agency, take it out of that box and enforce it. It was a third-party beneficiary contract.
Right, so essentially that decision prevents the judicial branch from creating some system outside the federal system. In this case, you're saying it's the same principle. We're just preventing the state executive and the legislature, or I guess legislature, from doing the same thing as the judiciary tried to do.
That is what we're arguing. In fact, Judge Johnston recently wrote an opinion. He's a federal district judge in West Virginia, explaining that specific type of conflict that we're talking about. So there's multiple sharp conflicts. One's with the shall offer provision, and one, of course, is here, and that is with the enforcement provisions. The state and the federal government have two very different ideas how to do this. And here in Astra, the Santa Clara County tried to go out and enforce it, as you said, in federal courts, but they were trying to get out of the federal regime. Here, Mississippi is also trying to get out of the federal regime. So in that way, they're parallel. But I might suggest...
If it's exclusive and therefore excludes the judiciary, it's exclusive and therefore excludes the states.
Essentially, you eventually get to the judiciary through the federal agency, right? You have APA review of the federal...
Right, I guess, but judiciary outside of the congressionally...
No, that's right. That's the parallel. That's the parallel, and that's what Judge Johnston wrote in his opinion recently. So the other thing I might say about Astra is this. What the Supreme Court did for probably the last two-thirds of that opinion was talk about what Congress's intent was. Why it's so important that HHS had the control reign over both Medicaid and the 340B program, and in particular the risk of conflicting adjudications. That is, that states or some other decision maker acting on their own would start making decisions about what had to be in a federal offer under 340B, and that could lead to chaos. That it was essential that this all work as one integrated whole, and that Congress chose, this is the very end of that opinion, that Congress chose that approach. Now, the Solicitor General told Congress that the 340B remedial provisions were the exclusive remedy for overcharges and other violations of this, for example, of the shall offer provision. So I think Astra, at the very least, tells us what Congress intended, and what Congress intended was to create one unitary regime for resolving these issues. So that takes me specifically to the state statute here, and if I might focus on the language of the state statute. For 32 years of the existence of this federal 340B program, Mississippi didn't think they had to legislate about this at all. There was no need to. It wasn't a health and safety issue. They had no need to get involved. Now, what they have done here is adopt a statute that is entirely parasitic of the federal program, meaning that it only operates to the extent the federal program is relevant. You can tell that from the definitions section of this act, which defined 340B drug and 340B entity by reference to federal law. And then it's section 4 of that statute that applies very specifically to the drug manufacturers here. And here's what it says. A manufacturer or a manufacturer's distributor, which is in reality how these transactions work, shall not deny, restrict, prohibit, or otherwise interfere with, either directly or indirectly, with the acquisition of a 340B drug or the delivery of a 340B drug to a pharmacy. Now, here's what that is essentially saying in this case. This is why there's a very sharp and irreconcilable conflict. If you have a one contract pharmacy policy, again, which was addressed in the DC Circuit case, or a claims data policy, what you are doing is saying you can't get the 340B price unless you agree to this policy. That's part of my offer. I will provide you with the 340B price if you agree to these two policies, depending on which drug manufacturer. And so the wording of this text, the plain meaning of this text is, a manufacturer or distributor shall not deny, restrict, or otherwise prohibit the access to 340B pricing. Both of these conditions, you have to ask, how do they not under this state statute? And that is interfering with the federal law interpretation of offer in federal statutory provision A1. That's what Judge Katsas wrote about. That's what Judge Bevis wrote about in the Third Circuit in that case. And I might say a little bit more here about the claims data provision while I'm on this particular section. The claims data provision, as I said, is a condition precedent to providing 340B priced drugs to a pharmacy. The covered entity for whom they're being ordered has to agree to provide this claims data. I think the state has said that they don't take issue with the claims data provision, but I'm not certain that they understand that it's a precondition to acquisition or delivery of drugs. And so I'll be interested to see what my friend says when the AG stands up here about the claims data condition.
You've got just a few minutes left. You've got other theories.
I do have some other theories.
It's up to you. I am curious, though, just in terms of the structure of your whole case, without intending to foreshadow an opinion, if hypothetically we were to find the law preempted, I take it we don't need to address the vagueness and the other issues.
That's right, Your Honor. I don't think you would.
What about within the different theories of preemption?
Sure.
It seems to me like there's your different theories lead to potentially different forms of relief. Am I understanding that?
So we have argued field preemption and conflict preemption here. Not impossibility, not that flavor of conflict preemption, but field and conflict. And I've, of course, been talking about conflict up to now because there are multiple very sharp conflicts, and I can go further into that. But field and conflict, as the Supreme Court said in the Crosby case, kind of run together. The real question is, what is congressional intent? How did Congress expect this program to operate? If I might add one more thing about this state statute, the Attorney General takes the position that it is only touching on delivery. Of course, it's delivery at a particular price, so maybe, delivery at a price is a pricing statute. But just, if I might refer to the text says the acquisition of a 340B drug by or delivery of a 340B drug to a pharmacy. If you say this is only about delivery, you're writing the acquisition clause out of existence. And acquisition, at least in Black's Law Dictionary, means to take ownership of something. It's not delivery. It's something entirely different. So I don't think, and perhaps this will come up in rebuttal too, I don't think that the state's theory that this is only a delivery statute and doesn't regulate the federal program is correct. It regulates what must be in a federal offer. So again, if I might, it's worthwhile comparing in great detail Section D of the federal statute and the way.
Say that again.
D. So when I refer to D, and I'm sorry to use shorthand, but D is the 2010 amendments that Congress made to this statute. It is very detailed, how enforcement, it contemplates iterative conversations between the agency and drug manufacturers to try to solve the problems before they mature into something that produces a civil penalty. As I said, there's an administrative dispute resolution, which is pretty unique as far as I can tell. And there's audits and all sorts of other very specific enforcement measures. The state doesn't do that. The state punishes the same essential conduct with different types of remedies, including criminal prosecution. And if you have any doubt that that's how this is operating, 42 CFR 10.21 is the federal regulation that describes how the administrative dispute resolution mechanism works. And the federal government takes the position that any effort to limit the availability of drugs is subject to its administrative dispute resolution mechanism. That's what the state statute is doing. These things cover the same waterfront, and they conflict. That, I think, is another sharp, irreconcilable conflict in the laws. Now, the Attorney General's briefing also talks about silence, and I just thought statutory silence. It is true that the statute does not say specifically that it governs delivery to contract pharmacies, but the shall offer provision is more than broad enough, as Judge Katz's opinion shows, to address the question of what is a reasonable condition in an offer, delivery or anything else. And he essentially explains how that will operate going forward. If I see that I'm out of time, Your Honor.
You've saved time for rebuttal.
Thank you.
Thank you. Mr. Stewart.
Thank you, Your Honor. May it please the Court, I'm Scott Stewart on behalf of the Mississippi Attorney General. I'd like to pick up where my friend left off, or just about left off, with respect to statutory silence. I think the core point here for the lead claims in this case is, what do you read into silence? And the conclusion I think you need to reach here is that nothing in silence, nothing in Section 340B blocks states from regulating delivery and distribution of drugs by contract pharmacies. Section 340B, it's silent on delivery, it's silent on contract pharmacies. That's the Third Circuit Sanofi decision at page 703, the DC Circuit Novartis decision at page 760. And the question is, what conclusion should this court draw from that silence? And the fact, and Judge Bibas, I think, put this well, silence doesn't speak. It doesn't impose duties, it doesn't confer rights. And the dispute in this case is much around, do you take from this silence the idea that this silence gives drug makers the unilateral right to dictate delivery conditions, or does it just not take a side on that question? Does it not compel a particular outcome, so it's up to state and private actors? And our view is that silence doesn't pick a winner. It doesn't take a side. It leaves it up to state and private actors, however that might shake out. And I'd emphasize that I think that's particularly compelling when you consider a number of features here. One is, we're talking about getting drugs to patients ultimately. Drug delivery and distribution is absolutely vital for this program to have any point. If drugs don't get to patients, the 340B program is pointless. If they just sit in a storeroom at a hospital spoiling or not getting to anyone, there's no point to this. So you have to have delivery and distribution. And even though you need that, the federal statute just doesn't address it. And the best reading of that silence...
I want to make sure I understand your point, though, because I'm wondering how it cuts. If we're agreed, as you said, that the vision of Congress is to let the players work it out, then doesn't the purpose of the state law essentially to dictate the terms by which the parties work it out? You're not letting it happen.
We're not.
Why isn't that a conflict?
Sure. So we're not changing any terms on which federal law takes a side, Judge Ho. I mean, at every turn in the 340B statute, the focus is on price. What's the ceiling prices of this drug? What hospitals or covered entities get this price? How do you make sure that these hospitals don't give it to people who are non-patients? It's all about enforcing price. The law does not override other background principles of law, just normal health and safety matters, delivery, consumer protection, just the background panoply of laws that you have, just existing in states to begin with. So federal law takes a side on price, and it enforces that price. And that's what at each turn you kind of see. I mean, my friend mentioned the 2010 kind of expansion of the dispute resolution process. That dispute resolution process is about enforcing the price, overcharges, diversion, duplicate discounts, making sure that it's all about price. But it is silent with respect to how delivery to patients is going to occur, even though I think it's quite fair to say that Congress could be presumed by 2010 to know that, hey, there are a lot of intermediaries, potentially pharmacies involved in this process, and despite knowing that, Congress did not say, hey, that's not allowed or you can't do that. My friend also said kind of like, well, what do you make of the fact that for 32 years Mississippi didn't act on this? Well, these new drug maker contract pharmacy policies, by all indications, didn't start coming out until about 2020, 2021. Things played out with HHS, Novartis, Sanofi, those cases for a bit. And then when, Mississippi, like other states, saw what was going on and said, hey, this is a real problem. We need to be able to get these drugs to people in need. We are going to step in and act. So anyway, I think to just kind of bring it back to a couple of my friends' points and just, I think Astra, this is kind of a similar point to go to your colloquy with my friend, Mr. Perry, Judge Ho. Astra, it involved overcharging claims. And when you see late in the opinion this whole kind of, this whole sort of, the importance of HHS having the control reign of the statute, I mean, you notice that the Supreme Court in that case cited and quoted the United States' amicus brief. And you look at that amicus brief, and what the government is really talking about is computing the price in this context involves difficult calculations about average manufacturer price, best price. It affects two different major federal programs. So if you have a bunch of people like shifting around the price and making different decisions on price, it ramifies across the program. So again, it comes back to the whole, you don't want conflicting adjudications on price, but adjudications on delivery and distribution of drugs is a completely separate, different thing. I think this kind of gives me a good in to just go to the statutory language. I mean, again, there's no kind of disputing that what this statute is really going after is these restrictive kind of one contract pharmacy policies. And, with respect to my friend, I don't think he read kind of a very important part of the statute, which is these are drugs received and, these pharmacies are receiving and dispensing on behalf of covered entities. They're covered entities who were entitled to buy these drugs, to pay these prices, and they're just trying to find out a way about how do we get these to people in need. I mean, you take Mississippi, and this is reflected in the record. We have the University of Mississippi Medical Center in Jackson, Mississippi, but it serves folks all over the state. And if somebody has to come to a single pharmacy in Jackson and make a 5-hour round trip just to get one of these drugs, because that's the only place they can get it at a lower price, that's going to be cost prohibitive or very difficult for some people. I mean, this really does affect access to drugs, and it really is a delivery regulation of drugs.
How is it a delivery regulation if what's at stake here is who's entitled to this negotiated price?
Sure, Your Honor. So I think maybe an easy way to think of it is it's the covered entity who's entitled to the negotiated price. And I think a good way to see it appreciated as a delivery regulation is to say that, if a covered entity said, look, send it to me, my one hospital, my one location, there's no real disputing it would have to be sent to that one location. So UMMC, University of Mississippi Medical Center, says, send it to me, send it to us in Jackson. That's, I don't think there's a real argument that they can't do that. It's only when UMMC says, hey, send 30 units out to these different rural hospitals so they actually are accessible by these patients. That is what ends up being blocked. So I think that does show that it again, on the ground affects delivery of drugs to these critical places so that patients can get them. Maybe another way to come at the issue, Judge Ramirez, is, there's this debate in the briefing, is this really about delivery? The statute says both the word delivery and acquisition. A couple of observations in response to that. One is they're delivery and acquisition of a drug that is bought by a covered entity. That's baked into the definition of the statute. The other thing is acquisition doesn't mean only ownership, it also means possession. And when you look at this law, it's pretty clear that the legislature was trying to sweep broadly and not leave any gaps in, because the legislature could reasonably look out and say, hey, look, these drug makers, they're very smart, they're very sophisticated. We don't want them to be able to kind of obstruct the purpose of the statute and find an out because we just sort of use the word delivery. Acquisition is basically like, delivery, sending a drug is not effective if it can't be received. So delivery and acquisition work together to make sure that very, very savvy, sophisticated drug makers can't come up with a policy that would somehow, maybe not block the drug at the front end of sending, but block it somehow at the back end. So that's what we're trying to do, and it's reinforced throughout the statute. I mean, the statute, again, it uses a lot of, terms to make sure it covers its bases: directly, indirectly, deny, restrict, prohibit, or otherwise interfere. But acquisition, it's not just sort of it relates to, it basically means successful delivery, getting it to the actual place where it needs to go.
So let me see if I can understand how your delivery argument works. Imagine a state law that says we want to protect the delivery of pharmaceuticals generally, nothing to do with 34B, just when you're transmitting pharmaceuticals or any number of other products, you have to use FedEx. You have to use a secured, some sort of specific type delivery. I take it that's your point, is that would not be preempted by this language, because that would be a delivery statute.
Right. I don't see any preemption problem in 340B with that one.
All right, okay. But here's my point, or here's my question. That's not this case, right? This case is not about the state's prerogative to regulate delivery mechanisms for its own sake. This is a situation, I think, where the method of delivery has direct price consequence. They're trying to avoid diversion. The plaintiffs are trying to avoid diversion to ensure that the prices are being set correctly. Isn't that very different from my FedEx hypothetical?
Well, I think, Your Honor, there is a risk during this of diversion, and that would, if there is diversion, that would be a violation of the statute itself. But the delivery requirement is not trying to sort of enforce or address or undermine diversion kind of risks. It's not trying to get at what the federal statute is trying to get at. It's just trying to, again, it's trying to operate consistently with the federal statute. It doesn't allow diversion. It doesn't touch diversion. It doesn't change prices. It doesn't change duplicate discount prohibitions. It doesn't change any of those things. It accepts all of those. It just kind of acts to ensure delivery. I mean, if there are claims of diversion, those would have to be brought to HHS, and the state would need to respect whatever those claims are. I mean, we're not looking to reach that. I mean, again, I think my friends know that there's nothing inherent. I mean, I don't think they say that there's anything inherently diversionary about using a contract pharmacy. I mean, I think it's hard to dispute that you need somebody with the appropriate permits, licensing, expertise, whatever it is to deal with those. And this is just kind of making sure that all these things kind of work in a correct way.
Right, but it's possible I'm misunderstanding a part of this. I thought the dispute was that the drug manufacturers want to set the terms of how this is done to ensure that the pricing is done correctly. I suppose one way to avoid this is simply to construe the statute, not to prevent what they're doing. I assume they'd be just as happy with that, but that's, I take it that's not how you all construe your own statute.
Well, I mean, no, Your Honor. I mean, I think, there'd be kind of a number of problems with that. I mean, one is that we are not ourselves regulating price. I mean, again, really any regulation in some way. I mean, if they're subject to state tort suits or kind of other general things, I mean, that could be said to, interfere in some way. But if we're not regulating, if all we're regulating on our face and in fact is delivery, I don't see how that's, a conflict.
Can I try to simplify this? Because you all are up more on the legalese of all this.
My apologies, Judge.
No, it's a complicated program, but just very simply, if the position of a drug manufacturer is, if you don't charge the right price, we're not going to deliver the product, would that run into the statute? Because it is technically a delivery issue, but the whole motivation of the dispute is a dispute about price.
I mean, it sounds like a pretty direct regulation of price, Judge Ho. I mean, but again,
that would trigger the prohibition.
I mean, it sounds like that would be an attempt to. I mean, the way I'm understanding the hypothetical is it sounds like a direct enforcement of price, but there's nothing inherent in using.
So when you say that, you're acknowledging that would be preempted? You could not enforce the statute, the state law, because that would intrude on the federal pricing system? I'm not trying to put words in your mouth.
I'm just, as I understood the hypothetical, Judge Ho,
And I'm sorry, it's overly simplified, but the idea is drug manufacturer, and maybe this doesn't work, but my idea is drug manufacturer says, I am not delivering this product until I'm guaranteed that you're going to set the right price. I'm just trying to avoid all of the complication. And we agree that that would fall within the federal system and therefore be preempted.
Well, I don't think the federal system regulates what the covered entity has to charge itself, Your Honor. I mean, the price term is what has to be presented by the drug maker, and then it's, that's kind of set by federal, it has to be under a ceiling price. I don't think that, I can't readily see how a drug maker can kind of dictate the back-end price set by a covered entity. I mean, I've never seen, they've made many arguments, and I've never seen them make that argument. Maybe another way to think of it, Judge Ho, is, again, I think a comparison and contrast to the the Supreme Court's Arizona decision, it dealt with both some field preemption issues, some conflict preemption issues. These are about pages 400 to 407 of that opinion. And, with field preemption, for example, you're looking, is there a dominant federal interest in this area? And the court said in Arizona, hey, in the area of alien registration, there is a dominant area. Look at all of these registration requirements, all these kinds of things. You have nothing like that here with respect to delivery. There's no dominant federal interest, pervasive regulation of delivery. Now take conflict preemption. This deal with the hiring of unauthorized people who are present without authorization. There was a system where Congress set up, okay, here's what's prohibited. Here are the prohibitions on employers. There's criminal prohibitions for them. Here's how we deal with unauthorized employees. We're not going to punish them criminally. There are all these other things that could happen to them. But it has addressed the issue in a way that shows it tried to go so far and no farther. Here we have really quite a different situation where, again, we have a statute that doesn't exhibit any kind of opinion about this at all. It just doesn't express a particular outcome, doesn't compel a particular outcome, does not pick a winner. And it is really a delivery regulation because it, as a matter of fact, affects whether people on the ground are able to access these drugs. If I can maybe, I know we have a second argument today, Judge Ho, but I may briefly touch on the two other claims just so I have a chance in case they come up later. Extraterritoriality, I think the point here is pretty simple as to why this claim fails. The district court had it right. And that's that nowhere does this Mississippi law say that it applies to wholly out-of-state transactions. And so
we can construe the statute to avoid this as well.
Right. All you do is construe it to it doesn't reach.
Not expressly extraterritorial.
Right, exactly right. That's how it's different from the Eighth Circuit decision in Stygzinski, which had a very detailed geographic scope provision that made clear it applied to wholly out-of-state transactions. With respect to vagueness, the district court again had this one exactly right. It really, for a number of reasons, it's a failure of proof on the plaintiff's part. There's no dispute that this law has many clear applications. It's a complaint about one word. It's the word interfere, but there's no dispute that there are heartland applications as to it's these one pharmacy limits. Nobody is kind of unclear that it applies to those. This is a facial claim. There's no meaningful as-applied claim. It's pre-enforcement facial, so you don't have really any facts to deal with. So the district court was absolutely right to reject this, especially given the facial standards. My friend has made the suggestion that, hey, we asked for something different from facial 2, alternative, kind of like something limited to our members. There's no meaningful difference because, again, there's no concrete factual scenario that they have identified that is plausibly vague. So I did want to touch those two points. If I can close by just making sure that I touch on some of these things about, is this a pricing statute? Is this a delivery statute? Again, there are kind of a lot of different ways to think about this. The Mississippi law here, it doesn't affect or alter Section 340B pricing or eligibility. It just promotes health and safety by making sure these drugs that these covered entities are entitled to buy are sent to areas and patients in need. It's, again, quite different from what was going on in the Astra case, quite different from the things that the dispute resolution process at HHS contemplates, which again are for overcharges, duplicate discounts, those sorts of violations related to price. My friend, I think, I want to mention this idea that this federal offer requirement, all the plaintiffs have to do is offer. I think we started a bit here on this question about what is required under the federal offer. Just a couple observations about that. Again, I mean, nothing in Section 340B kind of goes outside the area of price. I mean, it is very clear that this offer deed, imposes requirements on price, but it does not give drug makers, again, the unilateral affirmative entitlement to kind of dictate terms. I mean, they're free to do it, but if state actors come in this area that federal law has not reached, they're entitled to do that. Again, that's consistent with the normal presumption against preemption that applies to laws in this health and safety area, consumer protection area, pharmacy-related area, those sorts of things. I'd also just kind of perhaps closing with this point again about just where I started with what to make in silence. I think Novartis and Sanofi, the D.C. Circuit and Third Circuit decisions, I think they put it well in kind of understanding that 340B does not speak to this issue of distribution and delivery and what kind of comes with that. I do think it's important to recognize that the context of the cases was rejecting a very, very hard-line position by HHS, which was, in essence, drug makers cannot impose any conditions at all, period, full stop. They have to just accept whatever somebody else, a covered entity demands, even delivery to the lunar surface, was sort of the colorful line in those cases. And that's a pretty narrow rejection. And I think the important key points of the opinion for our purposes are the silence with respect to delivery and distribution, which again is absolutely vital to making the 340B program work. You need it some way, somehow. It surely has to be regulated some way, somehow. And the question is whether, do drug makers get to be the regulators, or is there also room for states? And there is. The court should affirm. Thank you, Your Honor.
Thank you. And I know we'll see you in the next case. Mr. Perry, you have 4 minutes.
Thank you, Your Honor. Let me just again, to respond to my friend's statement, refer the court to Section 4 of the D.C. Circuit opinion, where it explains exactly how the shall offer works, the shall offer provision of the federal statute. It is not just limited, as I think my friend suggested, that case is not just limited to rebutting what the federal government is doing. It was responding at the government's request to what an offer can and cannot restrict in terms of delivery. So Section 4 of the D.C. Circuit opinion. Let me just make a broader point too. As I noted at the very outset, participating in 340B and making an offer, an appropriate bona fide offer to provide these penny prices, is the price of admission for drug manufacturers into Medicare and Medicaid, is the bargain that Congress struck. And what the states are doing is changing the nature of that bargain. Now, here we're talking about Mississippi, but there are already 9 or 10 states that have done this. And if you play that out, if they all can define the terms, delivery or otherwise, in a federal offer, then you have perhaps 51 sovereigns, maybe DC, maybe you have more than that, defining what essentially should be a unitary federal question about what an offer is. It's chaos. And indeed, that is what the Rsrch court warned about. So let me, if I might, also make a very practical point about the enforcement provisions in the Mississippi statute. So say Mississippi were to proceed against a drug manufacturer saying you violated the restriction, you denied or restricted or prohibited or interfered with the delivery or the acquisition of a 340B drug. Why? The drug manufacturers would come forth and they'd have defenses to that. And the defenses would be federal defenses. And those defenses would include an argument that the patient who got this prescription was not genuinely a 340B patient, not treated in a 340B facility, but instead given, a 340B prescription by somebody practicing outside that facility. That will happen often. That the facilities themselves are not complying with federal law, that there are other reasons why there wasn't an obligation to provide a 340B discount, that the very offer provision we're talking about was appropriate. All of those will be essential parts of a defense to a state enforcement proceeding. Now, when I made that point in West Virginia, in district court, the West Virginia Attorney General said, well, we would wait and see how the federal government sorted that out. And the response by Judge Johnson was that would be chaos. This is a unitary federal regime meant to solve these problems without some sort of primary and secondary jurisdiction between the federal government and the states, and it just wouldn't work. Now, earlier I made a point about claims data as one of the two provisions, one of the two preconditions in the offer that a number of Pharma's members make. I was hoping my friend was going to respond about what exactly the position of the state is as to claims data as a precondition. He didn't, and I assume, as the district court noted, that perhaps they concede that that particular restriction, if it exists in state law, is preempted. But we need clarity on that point. My friend for just a moment talked about extraterritoriality, and in 20 seconds I'll try to sum that up. Our real concern is that the University of Mississippi Medical Center has contract pharmacies in New York, Pennsylvania, Hawaii, all over the country, dozens of them. We have no idea when we sell through our distributors sell to those pharmacies, that Mississippi law might apply. It's regulating entirely out of state. Thank you.
Thank you. The case is submitted. We'll now hear